Welcome to Client School. Let's talk today about determining your income for child support purposes. How do we determine what gross income is if you're working? How do we determine what your gross income should be if you're capable of working but aren't working or working as much as you could and should? That's when we look to Section 78B-12-203 of the Utah Code. In Section 78B-12-203, gross income includes prospective income from any source, including earned and non-earned income sources, which may include, it shouldn't come as any surprise, salaries, wages, and commissions, sure, but also royalties, bonuses, rents, gifts from anyone, prizes, dividends. It also can include severance pay, pensions, interest and trust income, alimony from previous marriages, annuities, and capital gains. It can also include Social Security benefits, workers' compensation benefits, unemployment compensation, income replacement disability insurance benefits, and payments from non-means tested government programs. Don't worry about what that means for now. Income from earned income sources is limited to the equivalent of one full-time 40-hour job. If and only if, during the time prior to the original child support order being made, a parent normally and consistently worked more than 40 hours at the parent's job, this extra time may be considered as a pattern in calculating the parent's ability to provide child support. Now, specifically excluded from gross income for child support purposes are cash assistance provided under the Family Employment Program entitled 35A, Chapter 3, Part 3 of the Utah Code. Don't worry about knowing what this is for now. It doesn't come up very often. Also excluded are benefits received under the Housing Subsidy Program, the Job Training Partnership Act, Supplemental Security Income, SSI, Social Security Disability Insurance, SSDI, Medicaid, SNAP or SNAP benefits, or general assistance. Also excluded are other similar means-tested welfare benefits received by a parent. Gross income from self-employment or operation of a business is calculated differently by subtracting necessary expenses required for self-employment or business operation from gross receipts. Income and expenses from self-employment or operation of a business are reviewed to determine an appropriate level of gross income available to the parent to satisfy a child support award. Now, this is important as to how that works. Only those expenses necessary to allow the business to operate at a reasonable level may be deducted from gross receipts. Gross income determined under this formula may differ from the amount of business income determined for tax purposes. What that means is that even if for tax purposes you can legally claim an expense that is not necessary to operate your business at a reasonable level, the state of Utah won't allow you to claim that business expense unless you can prove that the expense is necessary to allow your business to operate at a reasonable level. That can be really difficult to prove to a skeptical judge who is also himself or herself a salaried employee. Those of you who are self-employed know that rarely are you paid the same amount of money month to month, not like the person who works for an employer and is receiving a salary. How do you determine what your average monthly income is when your income fluctuates from month to month? Well, again, Section 78B-12-203 provides that when possible, gross income first be computed on an annual basis and then recalculated, divided by 12, to determine your average gross monthly income. That's reasonable. Now we're going to move on to imputation of income for people who are capable of working but who are either unemployed or not fully employed. To impute to someone an income means to treat that person as earning an income he or she doesn't actually have but is capable of earning. We impute income to parents who are capable of working so that they can't unfairly game the child support system by choosing not to work. To determine whether an underemployment or even an overemployment situation exists, the court can look to historical and current earnings. Income may not be imputed to a parent unless he or she stipulates to the amount imputed, or if the parent defaults, or in contested cases, a hearing is held and findings of fact are made by a judge or administrative officer as to the evidentiary basis for imputing income. If income is imputed to a parent, that income is based upon employment potential and probable earnings from employment opportunities. It can also be based on work history, occupational qualifications, prevailing earnings for persons of similar backgrounds in the community, or the median earnings for persons in the same occupation in the same geographical area as found in the statistics maintained by the Bureau of Labor Statistics. That's actually easier than it sounds. If a parent has no recent work history or a parent's occupation is unknown, income is imputed at least the federal minimum wage for a 40-hour work week. To impute a greater income than working full-time at minimum wage, specific findings of fact based upon the evidence for the imputed income amount must be entered. Income may not be imputed if any of the following conditions exist and the condition is not of a temporary nature. Well, this makes sense. Income may not be imputed if the reasonable cost of childcare for the parent's minor children approach or equal the amount of income the custodial parent can earn. It doesn't make sense to earn a living if you're spending it all on childcare so you can go to work. Income may not be imputed if a parent is physically or mentally unable to earn minimum wage. Income may not be imputed if a parent is engaged in career or occupational training to establish basic job skills. We're not going to penalize you for trying to take care of yourself. Income may not be imputed if unusual emotional or physical needs of a child require the custodial parent's presence in the home. Again, why send you to work just so you can pay somebody to take care of a child you can take care of? Gross income may not include the earnings of a minor child who is the subject of a child support award, nor can you consider benefits to a minor child in the child's own right, such as supplemental security income, SSI. But Social Security benefits received by a child due to the earnings of a parent are credited as child support to the parent upon whose earning record it is based. We credit the amount against the potential obligation of that parent. Other unearned income of a child may be considered as income to a parent depending upon the circumstances of each case. So what have we come away with here? Just know that there are many considerations when looking at the income for a parent. The easiest kind of calculation is if somebody is a salaried employee and receives a paycheck. You can just look at that saying, you know what, this person gets paid every month, every 2 weeks, and this is what this person earns month to month with regularity every single year. That's easy to plug into, and courts love that. Where you can run into trouble is if you're somebody who is unemployed or partially employed, underemployed. You may actually be imputed more money than you really earn. You're not going to be let off the hook if you've chosen not to work and are capable of working. If you are self-employed, that can be a real problem because it's very difficult to calculate. Courts don't like to do it. There tends to be an overestimation sometimes. Having to prove that all of your expenses are necessary to the reasonable operation of your business can make people who are greedy question every expense you have. Make sure you understand what the law is. Make sure you understand all the income that can be considered. It's not just what you earn at a job, but if you receive other kinds of unearned income, that also can be included in a child support calculation. Thanks for attending Client School. We hope to see you again soon.